This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
If you've been following the case against Bryan Kohberger, you know this isn't just another murder trial. It is a capital murder trial. 4 young victims, a country watching, and a defendant who's pleaded not guilty. And now, with just a few months left before the scheduled start of his trial in August, the defense has thrown up a massive legal flare. On May 20th, Kohberger's attorneys filed a motion seeking and asking the court to hit pause. They want more time, a lot more. And depending on who you ask, it's either a desperate attempt to stall the inevitable or a constitutionally necessary move to prevent a ticking time bomb of legal disaster. And let's be clear about what this motion actually is. It's not just a polite request for a scheduling tweak. It's a warning shot. The defense is saying if you make us go to trial in August, it won't just be unfair, it will be unconstitutional. They're arguing that this timeline violates Kohberger's Sixth Amendment right to effective counsel, his Eighth Amendment rights to a fair and reliable sentencing, and his 14th Amendment due process protections. That's not a legal window dressing. That's the core of the American justice system being put on the table. So what's the holdup exactly? According to Kohberger's attorney, the issue isn't just about needing a little more time to double-check their notes or organize some paperwork. It's about the mountain of discovery, the legal term for all the documents, all the evidence, the witness interviews, digital data, expert reports, and the prosecution that has to hand over. And in a case like this, where the death penalty is on the table, the defense is required to go through every single piece of it with a fine-tooth comb. Not because they want to, but because the law actually demands it. You can't defend a man's life with a half-read file folder and a gut feeling. In a death penalty case, every scrap of evidence has to be reviewed, analyzed, and if possible, challenged. That includes cell phone records, DNA reports, surveillance footage, digital metadata, you name it. The prosecution had months to assemble this mountain with the help of state and federal investigators, and now the defense says it hasn't had enough time to climb it. Or have they? There's a lot to this, and we're going to keep going in just a second, but I want to remind you, if you're listening to this on the podcast platforms, please hit that subscribe button. If you want to just listen to our podcast specifically about this case, the Idaho murders, the case against Kohberger is there. Just search it wherever you get podcasts. Or if you want access to all of our stuff, all of the cases, Hidden Killers with Tony Bruschi, look for that. And look for that on YouTube as well. Hidden Killers with Tony Bruschi. You can watch all of our coverage of this case there as well. And on X, Twitter, all of that, social media. On Twitter, at Tony B Pod. Tell me what your thoughts are there and in the comments on YouTube. So there's more to the case than just discovery. The defense is also working on what's called a life history investigation. And that might sound like a kind of thing you'd find in a memoir writing class, but in a capital case, it's one of the most critical parts of the process. This isn't about whether Kohberger did it. That's for the guilt phase of the trial. The life history investigation is about who he is, where he came from, what shaped him, what damaged him, what he struggled with. This is the groundwork for the penalty phase. And if he's convicted, where the jury decides whether he lives or dies. And to build that picture, defense teams have to dig deep. Medical records, school records, psychological evaluations, family history, trauma, potential genetic issues, anything that might help explain his behavior or serve as a mitigating factor to argue against the death sentence. It's not a sympathy tour, it's a constitutional requirement outlined in U.S. Supreme Court rulings and the American Bar Association's guidelines. And it's not the kind of thing you can slap together in a weekend. But keep in mind, they have had almost 3 years. The defense says they haven't identified all the expert witnesses that they'll need yet. That might sound like they're behind the curve, but they argue it's because they're still uncovering red flags in Kohberger's life that require specialized experts, mental health professionals, neuropsychologists, trauma experts, but they can't hire the right people until they finish the life history investigation. It's like being told to build a house when you're still dodging or digging rather, the foundation. Now, the court and the public are under a lot of pressure to move forward. The families of the victims, they certainly want justice. The public wants answers. No one wants to see the case dragged out for years. That's the emotional reality. But the defense is pointing out a legal one. Rushing to trial, especially in a capital case, can be a recipe for disaster. Not just a bad verdict, but a reversible one. Something that you can't undo. An irreversible verdict. Something you don't want to end up at. If maybe you got the wrong guy. Now, do they have the wrong guy? I mean, come on. This is certainly a tactic that they are using, though, and Taylor is throwing everything she possibly can at the wall. This is another string of spaghetti. But do keep in mind, you don't want to get to an appellate court, and they look at this a little differently, with the defense screaming, wait, we're not asking to change it, we just need more time. At least, that's what they're saying in this motion. But don't be fooled. There'll be other things they're going to say too. So this whole thing, you don't want it to be reversed. You don't want an irreversible verdict either if there's some problems. It doesn't just hurt the defendant, it re-traumatizes the families, wastes taxpayer dollars, and erodes public trust. But that's not all the defense is dealing with. They're also arguing that Kohberger can't get a fair trial in the current climate because of the media circus surrounding the case. And this isn't just the usual court of public opinion stuff. On May 9th, Dateline NBC aired that 2-hour special titled The Terrible Night on King Road. According to the defense, this wasn't just dramatic TV. It included details and visuals not available through any official public channels. Things like unreleased documents, private videos, and even cell phone data allegedly leaked from someone with inside access to the investigation. Dateline, of course, did not name their sources, but the defense is pointing the finger directly at law enforcement or the prosecution. It's a serious accusation, not because it's a courtroom issue, but because it undermines the integrity of the entire process. If materials under court seal are being handed off to media outlets, it calls into question the impartiality of the prosecution's team, and it taints the jury pool in ways that can't be untainted. Once you have tainted ham, you can't go back. And just in case the Dateline special didn't stir things up enough, there's more. James Patterson, the best-selling true crime author with a talent for turning real-life horror into airport paperbacks, has a book coming out. It's titled The Idaho 4, An American Tragedy, and it's set to release just 2 weeks before jury selection. The book's promotional language flat out calls Kohberger a brilliant grad student, loner, apparent incel, and it invites readers to play jury. The evidence is in, it says. Now you decide. Let's be honest here. If you're trying to seat an impartial jury, this is the worst-case scenario. You're not just competing with biased social media posts or water cooler gossip. You're competing with mass-market narratives dressed up as journalism or literature, released at the exact moment jurors are being selected. It is the world we live in, though. So I don't know how long we can stand on that as a crutch. And to make things even messier, the publisher brags about having unmatched access to people close to the investigation, suggesting that this legal problem isn't a one-off. It may be systematic. So when Kohberger's lawyers say they need more time, not just to finish their prep, but to let the media dust settle, they're not pulling that out of thin air. They're citing precedent in Shepard v. Maxwell. The U.S. Supreme Court reversed a murder conviction because the trial was so saturated with media bias that due process couldn't breathe. The defense is effectively arguing that they're watching a rerun of that same problem in HD and 24-hour coverage. Now, none of this is about whether Kohberger is guilty. That's a decision for a jury to make based on evidence presented in court, not commentary from a true crime documentary or the back cover of a thriller novel or a podcast. But it is about whether the process of getting us to that verdict will hold up in the long run. And right now, Kohberger's defense team is drawing the line in the sand. Either give us the time we need to do this right or prepare to fight the battle all over again on appeal. Nobody wants that. And that's where things stand. The clock is ticking towards August. The prosecution wants to stay on course. The defense wants to pump the brakes. The judge has to weigh public pressure, constitutional rights, and the increasingly toxic media environment surrounding the case. And all of it, every page of discovery, every expert not yet hired, every news segment aired in prime time, is building to a very public legal question. Not just whether Bryan Kohberger will go on trial for murder, but whether the system trying him can hold up under the weight of its own rules. That brings us to what's behind all this, the legal machinery that powers these decisions, the precedent that guides them, and the real-world stakes when the system gets it wrong. Because when you're playing with the death penalty, there are no do-overs, only verdicts that stick or implode. When the defense in Bryan Kohberger's case says death is different, they're not being dramatic. They are echoing the U.S. Supreme Court, and in the world of criminal law, that phrase is not a slogan. It's a warning label. It's the way of saying, handle this case like you would handle a live grenade, because the consequences don't reset. There's no parole from a death sentence, no chance to fix a rushed verdict if the process falls apart after the fact. Once it's done, it's done. That's the backbone of the motion Kohberger's attorneys have filed on May 20th. Behind all the legal language and the constitutional citations is one core idea. This trial isn't just any trial, it is a capital case, and that makes the rules tighter, the stakes higher, and the burden heavier, not just for the defense, but for the prosecution and the court, too. In legal terms, the concept is known as heightened reliability. It's a doctrine that says when the government seeks to take someone's life, the process must be nearly bulletproof. It can't just be fair. It has to look fair, hold up under scrutiny, leave no room for doubt that every safeguard was followed. That doctrine was reaffirmed in cases like Wiggins v. Smith, Andrus versus Texas, and the classic Powell versus Alabama. These weren't just procedural missteps. They were decisions where the court said essentially you can't execute someone after a sloppy trial. Take Wiggins, for example. That case involved a defendant whose defense team failed to investigate his background, missing critical evidence of childhood abuse and neglect, evidence that could have swayed a jury against the death penalty. The Supreme Court overturned the sentence, not because of new DNA or a challenged or changed story, but because the process was too thin. The preparation wasn't thorough enough. And that alone, the court said, was grounds for reversal. Kohberger's defense is leaning heavily on that very precedent. They're saying if we move forward, that same thing could happen. They haven't finished their mitigation investigation, a deep dive into Kohberger's medical, psychological, and personal history. They haven't hired all the experts. They haven't mapped out the narrative that would be presented if a jury does eventually convict him and has to decide whether he lives or dies. And in a death penalty case, that's not optional. It is not some bonus round after the main event. It's required. It's foundational. And skipping it or rushing it could compromise the entire trial, as much as that frustrates every person in the room. According to the American Bar Association guidelines for capital defense, which the Supreme Court has cited repeatedly, the defense must conduct what's called a comprehensive life history investigation. That's not just about whether a defendant has a criminal record, it's everything. Prenatal exposure to drugs, early childhood trauma, physical or sexual abuse, mental health diagnoses, learning disabilities, head injuries, substance abuse, genetic predispositions, and the effect of all that on a person's decision-making, emotional regulation, and moral judgment. The kind of investigation often spans 3 generations. It involves collecting thousands of pages of records, interviewing dozens of people, and putting together a narrative that can help a jury understand not just what happened, but why it happened, and what forces might have shaped the defendant into the person they became. You may be screaming, "Who cares? He did it!" Look, kind of in your camp there too. But this is how the law works. And if we don't want to continue this process on for the next 15 years, we do want to make sure it is done correctly, even if it is another string of spaghetti that Ann Taylor is throwing at a wall. In Kohberger's case, the defense says they're still in the middle of all of this. They've flagged the red flags. They've uncovered leads, but they haven't finished connecting all the dots. And until that picture is complete, they say they can't even know which experts to hire because it's not enough to just call a psychologist. You need the right psychologist with the right specialty who can speak credibly to the issues at hand. This is where the pressure of the timeline becomes more than just a scheduling issue. If the court forces the trial to begin before the mitigation phase is ready, the defense argues that Kohberger's constitutional rights will be violated before the first witness even testifies, and that violation could echo all the way to the appellate courts. The motion doesn't just point to the defense's own lack of preparation, it also points to the environment around the case. And this is where Shepard v. Maxwell comes in. That case, decided in 1966, involved a doctor accused of murdering his wife in a trial so heavily covered and sensationalized. And think of that, pre-social media, pre-cable television, pre-everything. Newspapers, radio, TV. 3 channels. But the media scrutiny on that one, the Supreme Court eventually threw out the conviction. The reasoning? A fair trial wasn't possible. The jury had been influenced before they even walked into the courtroom. Kohberger's team is drawing a straight line from Shepard to what's happening right now. Not quite the same, but, they're trying to do their job. They're pointing to Dateline, the Patterson book, the alleged leaks from inside law enforcement. Those aren't just media noise, they are potential constitutional landmines. If jurors walk in with options already shaped by these high-profile portrayals, the defense says it'll be impossible to seat a neutral jury. And that, again, puts the integrity of the entire case at risk. Now, the court hasn't ruled on the motion yet, but the defense isn't waiting to see how this plays out. They're documenting every concern, every obstacle, every element they say makes a fair trial impossible on the current schedule. That's not just for the record, it's for the appellate court. If this trial moves forward and ends in a death sentence, the defense wants a paper trail, a mile long, showing that they objected, that they warned the court, and that they did everything possible to prevent a constitutional misfire. That's the strategic lawyer behind the motion. It's not just about asking for more time. It's about protecting the case from future collapse, because in capital trials, the appeal is almost guaranteed. The courts tend to look very closely at whether the process was done right the first time, whether the defense had the time, the tools, and the access they needed, whether the jury was impartial, whether the sentencing phase was properly prepared. If any of those elements are missing, the conviction or the sentence can unravel, sometimes decades later. And here's something the public often doesn't realize. Delays like this aren't unusual. In fact, they're standard. The Parkland shooter sentencing phase took 4 years. Aurora Theater shooting, that trial started nearly 3 years after the crime. The Boston Marathon bomber was arrested in 2013. His trial did not begin until 2015. They're not outliers, they're benchmarks, because death penalty cases are inherently slower. They require more investigation, more expert analysis, and more procedural caution. Not because the defendant deserves special treatment, but because the consequences are irreversible. That's the core of the argument the Kohberger defense is making. Not that he's innocent, not that the prosecution case is flawed, but that the system has to work. It has to hold up under pressure, under review, and under time. And right now, they're saying it's not ready. Not because they're stalling, not because they're, well, maybe they are. Not because they're playing games, well, maybe they are. But because legally speaking, death is different, and the system has to treat it that way. Whether the judge agrees remains to be seen, but the motion has already served another purpose. It's planted the seeds for the next phase of the legal battle, whether that's a trial or years from now in a federal appeal court. Because in capital litigation, the trial is never the last word. It is just the loudest one. Give me your thoughts on this in the comments section, wherever you're watching this, YouTube or X, Twitter. If you're listening to the podcast, press subscribe there, and be sure to check out our video channels, YouTube, Hidden Killers with Tony Bruschi. Just search for us there. Or if you're on Twitter and want to follow this and many cases that we cover, just search me there at Tony B Pod. You'll find me on X, Twitter as well. Excited to see those comments about all of this. Should this be delayed further? It's not so much of a question of does he deserve it to be delayed further. It's more a question of what do we have to do to make sure this system works right the first time. If that means a little bit of a delay versus the potential for another 5, 10, 15 years of this thing having to be relitigated, having to get reprepped, all of that, and dragging the families through it, what would you rather take? It's a warning shot from Ann Taylor. Whether it would stand up to an appellate court is a whole other question. But again, it's a capital case, and that's where it matters. Tell me what your thoughts are in the comments. My name is Tony Bruschi. We'll talk again real soon.
Craving non-stop true crime updates? Press subscribe now and get the latest cases, analysis, and expert commentary delivered straight to your feed. Only from the Hidden Killers podcast and True Crime Today.